All righty, we are live. Welcome everybody to House Energy and Digital Infrastructure. It is Thursday, February 5th, and we are here continuing to take testimony on H740, an act relating to the greenhouse gas inventory and registry. Matt, we'll go around the room and introduce ourselves and then ask folks to introduce, and then we'll turn it over to you. So I'm Representative Kathleen James from Manchester.
Scott Campbell from St. Johnsbury.
Richard Bailey, Lamoille 2.
Chris Morrow, Windsor, Bennington.
Michael Southworth, Caledonia 2.
Christopher Howland, Rutland 4.
Graham Kleppner, Chittenden 13, Burlington.
Morris Billy over that too.
Dean Reed Perry with the Crescent Group. Nathaniel Eisen, freelance journalist.
Joanna Miller from Natural Resources Council.
Richard Dubé, Huntington.
Allison Descati, Vermonters for a Clean Environment.
Great. All right. For the record.
Matt Coda with Meadow Hill.
Okay.
If I could announce all my disclosures,
Yes.
because I wear a lot of different hats, and I do wear the hat as indicated in the schedule, managing director of the Vermont Vehicle and Automotive Distributors Association, and there is some nexus with issues that they have with this committee, but perhaps not this bill that I've been asked to testify.
I just noticed that. Go ahead. With the disclosure. Yeah.
I serve on the Climate Council, appointed by the Speaker of the House to represent the fuel sector. I previously served on the Clean Heat Technical Advisory Group and the Clean Heat Equity Advisory Group. My lobby firm represents the Vermont Fuel Dealers Association, which is retailers of heating oil and propane gas association of New England, which represents propane distributors across New England, the Vermont Retail and Grocers Association, which represents gasoline and diesel fuel suppliers,
Right.
and the heating, cooling contractors of Vermont that represent the people that sell and install heating devices.
Great. And I apologize. I hadn't noticed that on the agenda. I had thought to invite you to testify on this bill in relationship to your position on the Climate Council.
Sure.
And also as the lobbyist for the Fuel Dealers Association. I thought those were the two most relevant. Okay,
Absolutely.
sorry, I didn't catch that.
And certainly my role representing gasoline and diesel distributors
Right.
in the state, which
Okay.
is relevant to the registry.
Super. Great. Well, I know that you had signed a dissenting statement to the climate plan. So I don't know if you're going to talk about that, but we just want to get your thoughts on 740.
Exactly. I won't. Thank you for reading the statement that I wrote in June 23rd when the Climate Council passed. It wasn't unanimous. There were 5 dissenting votes, including mine. I'm just the only one who wrote a 4-page sign statement and talked about it.
All right. So 740.
740, a registry. So specific to the bill and the language in it, if I could be helpful and point out some of the issues that we see with the language as written, and then also provide an opportunity to understand how fuel comes into Vermont, how that data is tracked, and how we monitor it as a trade association, how the state collects it, and perhaps solutions going forward. So first of all, there are 139 different bonded and licensed motor fuel distributors in the state of Vermont. All of their information is collected by the Department of Motor Vehicles. Motor fuel distributor means that they sell gasoline or diesel fuel. They import it into the state and pay the excise tax to the Department of Motor Vehicles. Those gallons are reported, and that tax is collected by the Department of Motor Vehicles on the 25th of the month, every month. You can see we just updated this morning using DMV data. I don't have any inside track here. The gallons tracked over the past 10 years sold in Vermont at meadowhillmedia.com. You click on the fuel index. We update it every month, and we have December's numbers. So we know definitively what was sold in Vermont. But the data, when it comes to motor fuels, should be noted. It is the distributor. It is the person that holds title to that gallon the moment it crosses over to Vermont. As you know, we have no ocean, no sea terminal, and no pipeline. All of our fuel comes by rail car or by tanker truck. the 280 million gallons of gasoline and the 60 million gallons of diesel fuel that we sell every year in Vermont, we know definitively which entity held title to that gallon the moment it crossed into Vermont. We know this because they're required to pay excise taxes on it to the Department of Motor Vehicles. Failure to do so involves significant fines.
And you said that they pay excise tax and report gallons. This is the data that goes to tax, right? Gallons. Okay.
Yeah,
Just the Department of Motor. This is where, and I want to answer your questions. And I want to be able to point out because this is what's confounding. There are two different pools of taxation. One is the motor fuel pool and one is the heating fuel pool.
Right.
And sometimes they blend in together where we get lots of questions saying, well, why is that going there and that's going there? But when it comes to clear on-highway diesel, that's the stuff that goes into an engine that has a green plate, not a red plate, green plate, or gasoline. That's all collected by the Department of Motor Vehicles on the 25th of the month.
Mhm.
And we know definitively who those entities are that held title to that gallon because it's publicly available and reported to the DMV. What we don't know, and this gets back to the text of the bill, is what county it's sold in. That is not data that, I mean, we don't have any countywide statistics in terms of where it goes. When it crosses into Vermont, it could go, you could have a 9,000 gallon tanker truck going to Montreal, Port of Montreal, stopping by Enosburg and dropping off 2,000 gallons of gasoline, then stopping by Colchester and dropping another 4,000 gallons off, same truck, then doing the haul back to Montreal and coming back 3 times a day, every day. But there's no idea which part of those gallons. We know that 9,000 gallons came in and taxes will be paid on the 25th of the month, but we don't know if it was done in Franklin County or Chittenden County. And we certainly don't know whether someone from New York bought that gallon and then, burned 1% of it in Vermont and then went back to New York and burned the rest of the 99% of it. So in terms of tracking emitters, because the emitters aren't the fuel dealers. Emitters
So
are the people that buy it.
They don't know where it's delivered. You're saying, of course, they know where it's delivered.
They know where it's delivered, but that is not the county of which it might be emitted. I mean, the point of, I know what we want. We want better data. What I'm here to tell you is we have a significant set of data at our disposal that is imperfect. But what I'm concerned about is we're creating a system in which we will have a different set of data that is just as imperfect than what we really want. And I know this because I spent 18 months on the Clean Heat Standard Technical Advisory Group, and I saw what happened to the Clean Heat Standard Registry and how that hadn't effectively sunk that program because it couldn't figure out what actually we were tracking.
I don't think that's what sunk the program, but we could talk about that some other time.
Fair.
I have a couple questions.
Yeah.
So you said that we know how many gallons because we know the excise tax. But the excise tax is paid on dollars. Is it not, or is it paid on gallons?
Excise tax paid on gallons.
Paid on gallons.
32 cents a gallon goes to the DMV.
Okay, excellent. So that's how we know how many gallons. Are the gallons dropped to a regional distributor, or are they dropped they are dropped?
Yes.
So from there, it might go to a gas station somewhere else.
So all of the above.
Okay,
You can't have a teenager with AI fix this. I'm sorry. This
No,
is very complicated stuff.
that's why I'm asking.
We have gallons that roll in by rail car or by tanker truck. They either go directly to an underground storage tank, of which it then is dispensed to the traveling public.
Yeah.
Or it goes to a regional facility, in which is then picked up by a smaller truck.
Right. Okay.
So it's
That's good.
any of the above could have happened. And
Got it.
one of the things that if we're going forward with a registry to have better set of data than we currently have in our hands, we want to know going into this what we're trying to collect.
I think we always realize that motor fuels are going to be difficult to try to find any kind of geographical boundary.
Right.
That's just something. But we know how much is coming into the state because we have excise taxes on that fuel, and those excise taxes are tied to the number of gallons.
Yes, so that's correct.
We know that.
Yep.
Good.
Switching gears, heating fuels and sometimes transportation fuels are collected at the Vermont Department of Taxes. That list, thanks to the work of previous version of this committee, has greatly improved. And their collection system now, before you had to file a Freedom of Information Act, I did it every month, get the data. Now it's graphically presented. They have done a tremendous job in terms of providing that data to the public, in terms of how many gallons month to month are sold. Again, because the fuel tax, the 2 cents a gallon paid on the 25th of the month, all those gallons are reported, not by individual distributor, but in aggregate. And part of that is the distribution network for heating fuel is slightly different than it is for gasoline. And how it is then sold and resold is different in gasoline. When gasoline comes to the state, it may be sold, as Representative Campbell put out, to a regional terminal and then redelivered again. It's whoever owns title when it crosses the border, they're the ones that are paying the tax, right? Not the individual small gas station owner. But in heating fuel can come into the state and then travel outside of the state. Happens quite often. That was the problem we were having with the Clean Heat Standard Registry. What exactly are we tracking? Are we tracking the carbon molecule from the moment it crosses into Vermont to the moment it's consumed? Because that might change hands 8 times. It might go across the border twice in a day. It might come from across the border, come into Vermont, then go back into New Hampshire. This is the trail that we were trying to ascertain as we were trying to develop a clean heat registry. And I see the same challenges forming when we try to create this new registry.
On heating fuels, we have the fuel tax that funds weatherization, that I think is also 2 cents a gallon, right? The gallon per gallon tax. So in-state dealers, or actually any dealers, out-of-state dealers, anybody delivering into Vermont would have a record of how many gallons are being delivered into Vermont. Is that correct?
So if you are a retailer of heating fuels,
Yes.
so in motor fuels, VMV, distributor,
Right.
Big trucks and trains,
Right.
Heating fuel retailer. That's what, so a major company that's bringing in, well, just gaze over out the window and you'll see Alliance Energy, one of the largest distributors of propane in Vermont. Rail cars come in every day and they fill up the tanks there, and then smaller trucks come in and move that gallons elsewhere. They don't pay the fuel tax. The fuel tax is not paid by the wholesaler in the case, or the distributor in the case of heating fuels, and in fact paid by the retailer, which makes it distinctly different, not just where you pay it, but who pays it.
Right.
Motor fuels from heating fuels.
Yes.
Further complicating it is the weatherization tax, the 2 cents a gallon. It doesn't matter what the purpose is. If it is one of the fuels that is where the tax is paid to the Department of Tax, they don't care if it's residential, commercial, industrial. They don't care if it's a nonprofit or a government entity. It's 2 cents on every gallon.
Right.
In fact, and I pointed this out, since it was created, the tax paid on dyed diesel, which goes into school buses, which goes into your municipal plow trucks, which goes into the farmer's tractor. That dyed diesel tax is not an excise tax. It is a weatherization tax that goes to the tax department. So we live in a world where we're actually selling diesel fuel, a dyed product, which is not excise taxable, but we do capture the weatherization tax on every gallon of dyed diesel sold to a school bus operator or to a town or for the plow trucks or for a farmer's tractor.
But what I'm getting to is, so we know the number of gallons by retailer, right? Because we know, because of the fuel tax, the weatherization fuel tax. Right?
Can I correct the record? We are publicly available and posted every month. We have the aggregate number of gallons of dyed diesel, propane, heating oil, and kerosene sold in the state of Vermont.
Yeah, but at the retailer level, we have records of how many gallons are sold. Those retailers also know where they have delivered that fuel, right? Because that's how they bill.
Yes, the delivery tickets of a retailer, correct. So if a retailer were audited for compliance with the fuel tax, they would have to distribute, like in any audit, tax audit that some of you may have gone through. They have to create, or the tax auditor will want to see a basket full of tickets. to determine whether or not they're in compliance.
Yeah, if a system were set up so that that data, which exists, of how many gallons are delivered to what address, if a system were set up to collect that data, we would have that data.
The tax department does not have that data
No.
unless it's audited.
That data would exist in a form that could be used.
Yeah, there would be a significant challenge in getting, remember, most fuel dealers, most gasoline sellers too, are small dealers.
But they have to have records about
They have to have,
how many gallons are delivered to what address.
they absolutely
that's
have
how they do it.
records, and they have to provide it under audit by the tax department.
Good.
And that information remains confidential.
Um,
My question.
Sibilia and then Klebner.
Two questions. First, trends. So I think you told us that there are now 139 bonded motor fuel distributors. How many heating fuel?
137 heating fuel suppliers. The number's actually grown.
Are
Are
they-
they not Representative Sibilia? The number of heating fuel suppliers in Vermont I've done this 20 years. Every time a out-of-state company purchases a bunch of small companies, it is a personal gut punch to me. As a kid that grew up in a heating fuel family.
So
But
I don't
I
have a
can
lot
tell-
of time with you, so I just want to thank you for answering that question. How many were there 10 years ago?
The same.
So we've lost none.
We lose them. It's a mature industry. We lose them and we gain them.
Mhm.
Every time a Suburban comes in or AmeriGas comes in and purchases a small dealer.
Yeah.
Peter Bourne, he sold his business. It is his right to sell his business to another company. However, in that wake, what happens is small companies pop up. Ondite, Alco, all these, Fox Fuel, 802.
Great.
This is,
Can you provide us with a list? Perfect. My second question is, with regard to the bill that we have you here testifying on, which is H 740. When we, in section 1, well, I'm wondering if you have suggestions, specific suggestions of language to improve this bill for us.
Yeah,
So-
and I have a related but different question.
so the 3 edits with regards to, they're not edits as much as flags. So including fuel suppliers is called up as a source of emission.
What line are you on? Sorry.
I am on line 6 on page 2. Yes. And I was confused by that. I think I know what we're after. We want to make sure fuel suppliers are counted, but we're not counting fuel supplier emissions. Fuel supplier emissions would be the gallons or the greenhouse gas emissions that are released from the tailpipe from those diesel trucks when they deliver fuel.
So do you have specific language here?
Well, and there'll be a rulemaking.
Just delete it.
And I want to focus everybody on the steps that this bill would envision, which is that A&R will be engaged in a rulemaking process with, I'm sure, plenty of chance for everybody to provide feedback there. So
Mhm.
So a comprehensive greenhouse gas emission reporting program, understood that, but singling out fuel suppliers or including fuel suppliers is confusing in that I read that as counting the gallons we use in order to perform the services that we provide, not in terms of counting gallons. If all we're doing is counting gallons and getting a better reporting system, then I think we should say that.
Mhm.
So when we go through the rulemaking process, we understand that we're not going to count the amount of gallons it takes for company A versus company B in order to deliver the products that they deliver.
So if we were to make this a more inclusive list, so I read this as making sure that we're including specifically that if we were to expand on that list of including, that would be better?
No, this reads to me as fuel dealers count how many gallons of fossil fuel that you use in order to deliver your products. That does not say if all we're doing is creating a better system, a more distinct system of counting gallons. I think we should say that, and I think we should have specific guidance for A&R before they begin their rulemaking on what actually you want. Do you want every gallon that crosses the border?
So it doesn't actually say that though. So it talks about creating a comprehensive greenhouse gas emission reporting program that covers all sources of emissions, including fuel suppliers.
With all due respect, fuel dealers are not the source of emissions. The customers that burn their products are.
Rep. Kleppner?
So when you say fuel suppliers and fuel dealers are interchangeable language, because it says here suppliers, you said dealers.
Suppliers yeah. Suppliers and dealers are interchangeable. Distributors is a different terminology. Distributor versus retailer.
Yeah.
Wholesaler, distributor, retailer. Those are distinct things in my mind. Suppliers and dealers are largely the same.
Yeah. So I do understand Mr. Coda's suggestion that this is unclear. Including fuel suppliers does sound like the emissions that the truck delivering the fuel produces, not the emissions produced by burning the fuel that the truck delivered. But that wasn't my question. My question was, with the retailers, for heating fuels, do we have a sense for how many of them, have customers across the various borders of Vermont, and sort of as a percent? I mean, can we rough cut how much of it gets burned in Vermont is my real question.
Boy, that's a really good question. And what's complicated, having gone through the clean heat registry dilemma, is that, so say you've got that facility right there in Berlin, one of the largest propane wholesalers in Vermont. You've also got one in Bellows Falls in Rocky, Vermont. Both those, you would think, well, one's in Bellows Falls and one's in Montpelier, you'd think they would just be Vermont companies. A lot of those gallons are coming in because of the way that our rails are set up. And we rely on rails, and we need rails to move commerce around the state, goods around the state. A lot of the gallons that you watch the trucks that come out of Berlin, or you watch the trucks that come out of Bellows Falls, they're not stopping at a regional plant in Vermont. They're going to Massachusetts. Some are going to Connecticut. A lot of them are going to New Hampshire. A lot are going to New Hampshire. So even gallons that come in are just here pausing and then leaving. With regards to individual retailers and how much of their percentage, it varies greatly depending on retailers. We have New Hampshire retailers that sell some of their product to Vermont, Vermont retailers, some of the product in New Hampshire. That is the most porous border,
Yeah.
clearly,
Yeah.
rather than New York or Massachusetts.
Or Quebec, yeah. So the stuff that gets transshipped, are we collecting 2 cents a gallon on that?
Only this is where, if I could design it again, but we have what we have. Motor fuels collected on title at the point of into Vermont. Heating fuels collected at the retail level. So the big wholesalers,
Stuff that gets transshipped, we don't collect them.
if it's coming into Vermont, if a propane gallon is coming back from Quebec to Berlin, put on a 9,000 gallon tanker truck and driven into Massachusetts, nothing.
Yeah. Okay.
But if it's purchased by Gillespie in Northfield,
Yeah.
and then they deliver it to your house in Montpelier, yes, 2 cents.
Yeah. And if they pick it up here and deliver, if they fill some houses' tanks between here and the river, and then they cross the river and fill some more, we're collecting 2 cents on all of that.
No, you're only collecting on the gallon is delivered into Vermont.
So the stuff delivered to Vermont homes.
Right.
So they keep track of how much they're delivering in Vermont, how much they're going across the bridge.
Well, they certainly can pay for the 2 cents for a gallon sold in New Hampshire, but they're not required to by law.
Okay.
So simple math would be, I sell 90% of my product in Vermont. I'll just multiply my gallons sold this month by 2 and then send in a check. But if you have the wherewithal, you go, well, no, 10% of those gallons are sold in New Hampshire. I can prove that under audit. And then you only send in what you sell in Vermont.
Got it. Thank you.
Can I get back to motor fuels for a second? So you said, if I recall correctly, that when a motor fuel is imported into Vermont, that's when the tax is paid, when it's delivered into Vermont.
Yeah, whoever has title when it crosses into Vermont.
Yeah, so if some number of those gallons, some portion of those gallons are transshipped from a distribution point in Vermont, outside of Vermont, is there a credit for that, or what happened there, or that excise tax has been paid, and that's just how it goes?
Yeah, and so as I have to show you the form in which you indicate which gallons. state in Vermont.
Okay,
So the form that it's a CBO form.
they're in the way of knowing anyway.
Yeah.
Of how much stays in Vermont.
It's similar to if you deliver a gallon of clear diesel to a customer such as a school bus operator or a municipality. If you deliver a gallon of clear diesel, there's a way to get the money back on behalf of your customer.
Okay.
As well,
That,
there's a whole
I just wanted-
debit and credit system.
I just want to clarify that one point. Okay.
Jerry, you've been very generous with your time. Can I just make two real quick points? I'm happy to stay as long as you want, but
Well, we have other witnesses coming in at 1:30. I had a final
just
question, just comment. Yeah, go ahead.
if I may.
Yeah.
I'll be very quick. County doesn't work. Zip codes, sure. Counties, I've been asking drivers to know what county they're in versus knowing they know what the town they're in, but I don't know why we have county. I don't know what benefit does it serve having a county as another line on your code that will cost money. The other is we don't track whether it is, understand how greenhouse gas emissions, how the EIA calculates it, and how it would be nice if it would neatly lined up with residential, commercial, industrial RCI. We do not know in most cases what if it's RCI or not. Even transportation, we're selling a gallon of distillate. That same gallon of distillate, taxed differently, different purposes, could be for a vehicle, could be for outdoor use, as in tractors, or it could be for heat. It's the same gallon, same thing, but we don't track in our data what if it was residential, commercial, industrial. It's a guessing game. So I understand why that is wanted, because it helps match up to the previously collected data from EIA that is horribly late. I agree with Secretary Moore. It comes way too late. This comes on the 25th of the month, every month, available 45 days later. However, us getting to a county-wide level or a RCI level, it seems, I don't know how that happens. And the second point is, and the last point is confidentiality. If we know exactly how much which gas station and which company sold, there would be some concerns about the competitive advantage for some of the small companies. Thank you.
Is it related to the bill?
It's related to this, which was just, so I noted that there are New Hampshire companies in here. Are you counting that as the 139?
I only count them if they deliver into Vermont.
So, okay, thank you.
Great. So just, I guess just a reminder, for the committee mostly, which is that, we asked A&R to develop a memo to look at this greenhouse gas reporting framework idea, because folks agree it's important. And I think you agree it's important, or maybe you don't agree it's important. I don't want to put words in your mouth, but a wide range of entities agree that this expanded or improved reporting framework would be a foundational step to build better climate policy, which I think we all share an interest in doing. And so this bill does not flesh out or develop that policy. The only reason we need a bill is that A&R has done significant research, and A&R would like to engage in the rulemaking process to use existing data and engage with all the stakeholders to hear these kinds of comments and develop a reporting framework that uses existing data that will be useful. And so we are not designing the program here. A&R has said specifically that it would be helpful to them to have specific legislative authority to embark on the process of a rulemaking step. So I just want to remind folks, A&R wants us to say, please go do this. We are not designing the program ourselves. And so I guess I felt it was important to just remind folks as we get into our questions and stuff. This is A&R saying, we've researched an idea. We think we can make it work. Will you please give us permission to go and do the rulemaking work, which is when we really dive into the nitty gritty. So anyway, I just felt that was an important reminder. So, and I'm sure as part of the rulemaking process, what data fuel dealers have available would be critical consideration. So All right.
Thank you for your time.
Yeah, thank you.
Thank you.
Matt, I'm sorry I didn't see. Did you submit written testimony? Okay,
Although I can submit my June 23rd signing statement, but interest anyone?
I think it's already.
It's
I
7 months-
have it. I
It's
know.
7 months stale.
Huh?
It's stale by 7 months.
I'll make sure it's posted. I have it. I'll make sure it's posted on our website if it's not already.
Sure. Thank you.
All right. Thank you for being here. All right. What do we do next? Are our next folks here? Great. Oh, there. Hi. Hi, Victor. Alrighty. I think we can just move on ahead. I don't think we need a break. We just got started. So, we are turning our attention. Everybody has to do a mental shift. We're going to turn our attention back to H710, which is our bill about the definition of plant. And I know that I believe that our attorneys at the attorneys at the PUC have been in touch with Ledge Council to try to work on updated language.
That's correct.
And that's what we're talking about now, right? Okay. Okay. For the record, if you could introduce yourselves.
Yes. Thank you, Chair James and committee members. I'm Steph Hoffman. I'm the General Counsel of the Public Utility Commission. And with me today is Wes Skidmore, staff attorney. I apologize. I'm trying to connect here and share my presentation.
No problem. Did you did you submit
Did you
this? I'm
get
just
it?
wondering if we have it.
Sorry.
Did you get,
Yes. I did share it yesterday, late in the day.
Great, it's probably posted then. Let me just look. Yep, it's on our website. I see two documents. One might be,
I just refreshed on the sharing the report again, just so we all had that readily accessible. The other are some slides.
okie dokie. Do you want to share your screen or do you want us to follow?
I'm happy to share my screen. My computer is somewhat cooperating.
Okay.
Sorry.
Okay. Yep, I do see we posted your November 12th recommendation, the legislative language that was workshopped. And then I see testimony from today that looks like 4 slides.
That's correct.
Okay, super. If you're not able to share your screen, we can all pull it up.
I will get started here and Wes that he's gonna join in.
Just be about 1 minute.
Okay.
So we heard the testimony last week, and so we know it was discussed then, and we wanted to come back to you with some language to address the concerns that we were hearing, in particular clarifying exception C. Before I present the language that we had been talking with Ledge Council about, I wanted to walk through what that exception is meant to do in hopefully some clear terms, and then show the new proposed language to capture what that definition exception is supposed to do.
Okay.
So as a reminder, this is the exception that overall deals with what happens when you want to place a net metering system, a standard offer system, and then other forms of solar generation technologies on the same parcel or contiguous parcels. This definition at a high level is meant to prevent more than 500 kW of net metering capacity or 2.2 megawatts of standard offer project capacity on a parcel. So meaning we were preserving the statutory caps without any additional capacity on those sites that could be looked at in aggregate and then violate those capacity caps. But to allow projects that are basically under the res or have PPA contracts and other forms of contracts with utilities to exist as many as are appropriate for the parcel under the criteria, so long as they have different points of interconnection. So basically, under this current definition, not the one that's being proposed to change it, you can't have additional capacity when you have a net metering system or a standard offer system, because we have to look at under that definition, the total amount of capacity on a parcel and say, does this violate the program? If the answer to that is yes, because they're proximate, it violates the definition and that screens them out from being able to co-locate. Under the new definition, the attempt here is to say, so long as compensation for capacity at the program level is capped at the appropriate amount, 500 kW net metering, 2.2 standard offer. Beyond that, you can put more capacity on the site, just can't be compensated under those programs. So you can have additional PPA projects on that site. And by the way, if you don't have net metering or standard offer, we are not using this as a screening mechanism, and we're not going to prohibit more capacity.
Okay, two things. One is, it looks like we have somebody wanting to enter.
That's
Is that
that's
you?
me. Yeah.
Okay.
You just need
Can
to
somebody just press that?
also just hit it.
Press this blue, nothing but.
touch the screen.
Yeah, if you don't mind. Sorry, I find that so distracting.
Thank you.
So if you could just say it again, slowly. So,
And it helps if you're able to look at, when using the pull it up too. This first slide here is going to show you under the proposed definition what can be cited on a parcel. So if you
so this is what you're going to walk us through what we're
Yeah.
trying to achieve, and then we'll talk about the language.
yes, exactly.
Okay.
So this definition, the proposed definition for exception C, this is what it's trying to achieve. What can be cited? Pretend those rectangles are a parcel of land, and we're looking at what can be located on them. So under the definition of plant, the general definition that's proposed, you can have a single facility of any type can be cited on a parcel, presuming it meets the other statutory criteria. Once you have more than one facility on a site, you have to ask whether it meets the exception, right? Because we're looking at, are you on the same parcel or contiguous parcels? And are you the same generating technology? If so, then we have to find an exception. That's where we are. We're in exception C. All we're using in exception C to screen additional projects is the capacity caps for net metering and standard offer. Otherwise, we just look at point of interconnection. So in example A, this shows the green box is an example of a 500 kW net metering project. Under the new definition, you can cite a 5 megawatt res PPA project on that site, so long as they have different points of interconnection, which is almost always going to be the case for two facilities that are applied for separately. They don't share points of interconnection. That's an engineering issue. Can't share the point of interconnection, really. So that's one example that in the status quo's definition, you can't do this. You can't have that second PPA project on the same parcel. But under this new definition, exception A is allowable because you're not exceeding the 500 kW cap. Exception B, example B of exception C, 2.2 megawatt standard offer program facility. You can also cite a 5 megawatt PPA on the site. By the way, you could cite 10 5 megawatt PPAs on the site, presuming the site supports that, the other statutory criteria are satisfied, and you have different points of interconnection. But I'm just showing this as a simplified example of that scenario. Status quo does not allow this. The definition currently would not allow that PPA to be cited on that parcel. And then example C is showing multiple PPAs on the site. Again, 2 is just one example, but you can have more than 2 as well. So what is new about all of these examples? Oh, sorry.
Did you have a question?
Well, I don't know if I don't want to interrupt your.
I don't either. I want to hear what's new. Yeah.
So go ahead, and then I'll try to remember my question.
Sure. So what is new here is when you're looking at these parcels, seeing multiple projects on the same parcel under the current definition, if there's a statutory capacity cap that's being violated by putting those multiple projects, it's screened out. It cannot exist. So if you've got net metering or standard offer, there's no question of that. If you have multiple res projects, it's a gray area because we are using the same definition in that category. And so we have to apply it in essentially the same way. There's not really an exception within that definition currently for res projects. So we end up screening out some multiple res projects that are on the same parcel.
Okay. Let's see. If you have a net metering project or a standard offer project that has not the capacity of the existing facility does not, is less than the statutory cap, can you add to those projects?
Yes.
Now, you can't, under current rules.
Yes, and I'll say yes. And it's not but and no in these circumstances. It's always yes up to the capacity cap. However, the definition is used not to screen projects out, meaning you can't build that project, but instead to determine what application is necessary based on the capacity size and what rate will that project receive.
So whether the additional capacity needs to have the current rate as opposed to the rate of the original facility.
That, but also different level sized net metering projects get different adders. So the credits are tiered. And so once you exceed a certain capacity amount, you're in a different rate credit calculation. And so we have to use some method of determining what is the project that is going to be given those credits. And that's decided based on if they're the same project, then we look at the aggregate capacity, and that's what application process you need to use, and that's what rate you'll receive.
Okay. And standard offer.
Standard offers a little more.
Is that different? I mean, is it simpler or is it more complicated?
It's less complicated because the contract is decided before the project is applied for, and you can't violate the terms of the contract. So if your contract is for a 1.0 megawatt project, that's the project you can build. You can't alter or amend that contract's capacity after the fact. They bid into the contract process, they receive their contract at the capacity they bid at, and then they can apply for the petition to get a CPG with us, and that's a separate citing process. They've already got the contract in place.
So that would be a separate contract, but it would still be limited by the 2.2 megawatt for the site.
Yes. So technically you could put two smaller standard offer projects on the same site without maxing out the cap in certain circumstances.
Yeah. Okay, and it's 5 megawatts. Is that a limit for a project on a PPA?
It is if it's attempting to be renewable energy standard qualified. The RES statute has a 5 megawatt capacity cap for RES qualification.
Thanks. This gets really complicated.
It is.
Yeah.
Is there any standard offer capacity left that hasn't been built or is already not contracted?
There's a small part of the standard offer contracts that were issued that has not been built or
Not
applied
been
for
built.
yet.
Has not been built nor applied for.
Yeah. Okay, so then on the next slide, I'm showing the one case that cannot exist under the new exception, which is you cannot put net metering and standard offer on the same site. Even though technically each of those plants would meet the capacity cap for that facility, because the policy rationales here are, these are programs that were intended to encourage dispersed generations, and siting of dispersed generation, co-locating them risks aggregating that capacity and violating both programs. And so the thinking here is when there's an economic incentive for the capacity, you shouldn't be allowed to co-locate more than the capacity limits for those programs on a single site. So that is, we're prohibiting still the co-location of a net metering facility and a standard offer facility.
And I'm sorry, that's same parcel, also adjacent parcels, right?
Correct.
Thank you.
So with that in mind, what we're trying to allow and what we're still preventing, we have proposed a new definition exception C language. Oh, sorry, this is not the right language. It's not, no.
I have a PDF I can pull up.
Okay, and we have different.
Yes, so there should just be two.
Mark has-
Okay.
That's what we have.
So if you have that in front of you, I can walk you through that. So exception C now says exception for co-location of facilities other than net metering program or standard offer program facilities. Applies if the facilities have separate points of interconnection, so long as 1, a net metering facility and a standard offer program facility are not sited on the same parcel or contiguous parcels. And 2, the statutory capacity cap for the net metering program or the standard offer program is not exceeded on the same parcel or contiguous parcels. So what you have there is essentially when you're adding capacity, a system capacity to a site where you have net metering or standard offer, then you need to have separate points of interconnection. And you can't violate one or two. So you can't have net metering and standard offer on the same site, which is what number one is. And you can't exceed the capacity cap for either program. That's what number two is. And that definition effectuates allows us to apply it so that all the examples we just shared are positive.
So lots for language.
And that's acceptable to the PUC, obviously, since you worked on it. And I think that we will need to ensure that it's acceptable to some of the other stakeholders that participated in the workshop. Yeah.
So for number two, if you had an existing 500 net metering, you would not be able to add a PPA for 500?
You can.
You can.
Anything outside of
Just
those two
that.
programs.
You couldn't add,
You couldn't have net metering or standard offer.
which number one already. covers. So why do you need number two?
Number two deals with the situation where the capacity cap for the systems can't be exceeded. So if you have a net metering facility on a site and you want to add another one to the question before, that's still allowed.
You'll do
So
that.
long as you don't have the
thank
capacity
you.
cap being exceeded. There are so many permutations here that that's why this language gets very complicated because we have to guard against
Right.
various different scenarios that could exist and we have seen. And so we're attempting here to thread all those needles, recognizing it is very repetitive sounding, and we're trying to limit the complexity of as much as we can.
Did you see the language that we wrote to simplify that?
I didn't.
No, send it to Ellen. Let me just find it and see whether it's better or worse than this language.
Well, I think Ledge Council has been working with, our attorneys have been working on the language, so
You like this better than what I sent you?
that, yeah, I
If
mean,
that's an easy yes, great. Like, if this is better, great.
Yes.
Excellent, thank you. Try to find. it.
Were we awaiting decommissioning language? That's good.
thought we decided that we weren't gonna go there.
Okay.
Rep. Howell?
So any of the costs of losses for these parcels being on the same circuit in close proximity to each other is dependent on the utility to recover in their PP, in their purchase power agreement.
I'll make sure I understand the question. When a new development is proposed, any type, net metering, standard offer, PPA, the cost of interconnection falls on that developer to upgrade the system.
Correct, but if you have outside of a city, a user, that the same electricity, the same amps are gonna flow from the same region area in facility to the load that's located back to the east, as the same amperage flows through the wires, the amount of losses increase. And that's why we like distributed generation, meaning that it's actually at one point in time, the utility said it was cheaper to put distributed generation out in the boonies than it was to build the power plant out to the boonies. So, and that's the concept of distributed generation. And when we put this two sites in close proximity, you're defeating that concept of distributed generation. And that's for the utility to respond to. Okay.
It's a lot more clear to me.
Yeah, do folks have questions about the language? So not on the, we don't have, him on the agenda, but, I see renewable energy Vermont in the morning. Peter, have you had a chance to review this language or are you looking at it now for the first time?
Peter Sterling, Renewable Energy Vermont. I'm looking at it for the first time. It looks fine. Appreciate that
Yeah.
PUC making it clear.
Okay, maybe, if you want to send a little letter to that effect.
100%.
Super. I think, if we've got language that Ledge Council, the PUC, and the primary stakeholders find acceptable, I think we could probably do an updated draft of the bill, unless you already have.
Yeah.
Huh?
Yes.
Okay. Super. All righty. Great. Well, I will take a look at our calendar, and see when we can, I'll keep committee members posted, see when we can bring this to a vote. Great. I can't remember if you had, any other feedback on the bill from your first presentation. I don't think so, because our first draft was taken directly from the workshop, and then, okay, so I don't think we're missing anything.
From our perspective, thank you very much for this opportunity.
Yeah, thank you for the opportunity as well.
Thanks, Steph. Thank you, Leslie.
So
Yeah.
all these blue ones are res qualified, the 5 megawatts of renewable energy
Well, that just simplifies that.
and not mega, 20 megawatt.
Yeah, these are just 5 megawatt reds.
Which need to rest. Thank you.
Great.
Thank you very much.
All right. Well, we can actually go off live. We're back at 2:30. With some more testimony on 753.